Okay, it looks like we've got a connection. Shannon, put us on the record. This is the matter of Pratt versus Employers Mutual et al. Counsel, state your appearances, please.
Paul Millenbach on behalf of the plaintiff, the estate of Justin Pratt.
If it please the court and counsel, John Schutze from Mary Farnan and Ryan, appearing on behalf of defendant Employers Mutual Casualty Company.
Schutze, it's spelled S-C-H-U-T-Z-A.
Perfect.
Do you have Millenbach?
Yep, I got that one.
Okay, gentlemen, I have read your briefs. So keep that in mind as you're making your arguments. Go ahead, Mr. Millenbach.
It's defendant's motion. I don't know if the defendant wants to go first, Your Honor. I mean, I can respond however you want to do it.
Oh, I'm sorry. I got you confused there. Yes, Mr. Schutze, go ahead.
Thank you, Your
Sorry
Honor.
about that.
Your Honor, at the outset, I would note that plaintiff's counsel has clarified in his response to this motion that he has not settled with the alleged tortfeasor driver. So I'm not making that related argument that was made in our motion. That was based on some discovery responses. However, plaintiff has also indicated that he is not seeking to recover no-fault survivor benefits from Employers Mutual Casualty Company. So at a minimum, we submit we'd be entitled to dismissal and summary disposition of that claim. Now we're left with the underinsured motorist claim. For sake of brevity here today, I'm going to refer to Employers Mutual Casualty Company as EMC. This case for underinsured motorist coverage, I submit, is principally governed by our Supreme Court's decision in the Rednor versus Hastings Mutual case and by our Court of Appeals subsequent decision in the published decision of Westfield Insurance Company versus Ken's Service. As used in the EMC policy in question, we're dealing with the word occupying, which the policy defines as meaning one who is in, upon, getting in, on, out, or off, close quote, an insured automobile. Now, in Rednor, the Supreme Court said for purposes of PIP benefits and the PIP statute that occupying means that the person making claim for benefits would have to be physically inside the insured motor vehicle. No party
He froze.
with, it appears, is the claim by plaintiff and to a lesser extent by the co-defendant USAA Insurance that at the time of the collision, the decedent was on or upon this garbage truck.
Well, let me stop you there. I don't get a sense that there's a strong dispute as to what the law is. Rather, the issue seems to be, what are the facts?
Okay.
Was he on or getting off this garbage truck?
I'd be happy.
And whether or not he was actually touching the garbage truck, I don't know that that's an issue unless he was touching it in the process of trying to get on it or trying to get off it.
Well, I'll be happy.
I mean, let me ask Mr. Millenbach. I mean, if he wasn't doing one of those things, on it, getting on it, or getting off it, would you agree that there's no recovery here from this defendant?
I would agree. I like the first rendition of you gave a little bit better, that if he was touching it in order to get on or get off it or was on it.
Right.
But
Yeah, and that's fine. If he's in contact with the vehicle, I guess even if he's not in contact, If he's hit as he's getting off, whether he's still touching it or not, then factually there could very well be some recovery. So that's what I wanted to zero in on, is this, what was he doing? I was a little surprised as I read what was submitted on that point, that, and maybe I missed it, there wasn't more development, in particular of the one witness who used the term, he was on the rear of the vehicle. I was trying to get an idea here of what even the back of this garbage truck looked like before it got impacted. Is there a place for the guy that's on the side of the vehicle that the driver was on to stand? Is there even a place for that?
There's a step that's on the rear corner of the garbage truck. Often you'll see garbage men or women, for that matter, sanitation workers, they'll stand up on that step and hold on to the handle as the truck's going down the road.
And I've seen that many times.
Yeah, and that step exists on this truck.
Okay.
All right, and I'd be happy.
Is there a plausible explanation for why he would have been standing on, stepping up, stepping down from that step, when the reason he's back there isn't to catch a ride to the next stop? He's back there to actually empty a garbage can into the garbage truck.
Because he saw the
and
truck
I guess
coming.
It's a question for Mr. Millenbach. Yes.
Because he saw the truck coming. That's the only thing that we can surmise, is that he saw the truck coming and he jumped up onto the back of the truck. But this is a question of fact.
Tried to get out. And I guess if I'm standing back there and I see a pickup truck barreling down on me, and there's no other thing to do except to try to get out of its way, I might very well jump up on the back of this truck or step onto it to try to avoid the impact.
Yeah, that's the only possible.
Was that developed with any of the witnesses? I mean,
Nobody saw it. The only one that was close was Tyler Street, the co-worker, and he was behind a lifted up can, and he was looking towards the front of the truck on his side of the truck, which would be facing east, to see how many cars were coming from the other way. So he didn't actually see the limits before impact.
So on the side of the truck that the other worker was on, does the device that lifts and empties the residential garbage dumpster lift it from the back of the truck, or does it lift it from the side of the truck?
The back. It's like a little flipper on the back of the truck that they connect.
And so there's a similar device on each side of the rear of this garbage truck?
I don't believe there is. I think the only device is on, there's one hopper, or there's one lift for the hopper that we're talking about, and the devices for that are on the passenger side of the truck where the witness was standing. Mr. Pratt was on the other side towards the street, or on the driver's side of the truck. So Mr. Pratt,
okay, well, that helps me, because I was under the impression that they could actually empty two dumpsters simultaneously. What you're telling me is there's only one, it can only handle one dumpster at a time.
yes. This truck, yes.
So and I'm sorry, Mr. Schutz, I don't mean to shut you out. I will give you plenty of chance to weigh in.
Thank you.
So the other worker, the non-driver worker, was actually engaged in emptying a dumpster into the truck when the impact occurred?
I think the chain of events is that Mr. Pratt had emptied, he went over to the driver's side across the street, brought a can over, put it on the lift. Mr. Street operated the lift because he's on the right side of the truck where the controls are. And then he lifted that back down, or he released it so it came down. And then Mr. Street, the other worker, then lifted his can and flipped it and emptied it brought that back down, and then apparently Mr. Pratt's can wasn't completely empty, so he rolled it back onto the lift, and Mr. Street operated the levers to lift it again to empty out the remaining contents of the can when the accident occurred. So his can was in the process of flipped up in the air. So as he's standing at the back of the truck, he's got a can next to him, and the other side of the can is Mr. Pratt. So he was in the process of emptying it the second time.
So at the time of the impact, did Mr. Pratt, was he in the process of moving the receptacle that had just been emptied back to its position on the other side of the street? Either beginning that process?
We don't really know that. We assume that that's ultimately was what he was going to do. But we don't know because nobody saw it, because everyone's view is obstructed, or the driver coming from the other direction couldn't see it. He saw him standing at the back of the truck doing what garbage men do, but he passed on and didn't see the accident until he heard it in his rearview mirror.
Well, if he was in the process of moving the other receptacle out of the way and back across the street, there should have been another receptacle involved in this impact, was there?
Not that I recall. I think the only one that I recall from the photos is the one that's located. You can see in the photos it's located on the back, on the lift, on the back of the truck. The one that Mr. Street was on. Okay,
I really couldn't tell much from the photos because it was such it was too close and it was kind of a mangled mess.
Yeah.
It's immaterial, but when I read the statement of the driver of the truck, he said he had just put their camper on the back of the truck and was driving out. I didn't see a camper. What happened to that?
It was there. It was on the back of the pickup truck. It was a pop-up camper. So it was kind of small. You might not have noticed it in the photo.
Oh, I got you. It wasn't a cab over camper. It was something he pulled behind the truck.
Yep, a pop-up.
I got you. That's what when he said he was hooking up the camper, I thought it was a cab over camper, and I was surprised when I looked at the picture that all I saw was an empty pickup bed. So thank you for answering that inconsequential.
He was driving a rusty old pickup that I think just used for camping, and he obviously didn't keep enough insurance on it. And he said the windshield was dirty, and he was going to clean the windshield. He couldn't see the windshield, but I mean that's immaterial to this case. But
so, Mr. Schutzer, you've been very patient listening to this conversation. Are there points that Mr. Millenbach has made that you would disagree with?
Well, not so much disagree with. I would like to augment what's in the record on this point, and it maybe clarify what could be a little bit confusing. Sergeant Niles, who came to the scene, was deposed, as the court knows. And when my partner, Mike Ryan, was taking his deposition, Mike asked him, where do you believe he was standing? And this is where I think we get some of the confusion from. Sergeant Niles said, I believe he was standing on the back corner of the truck, at least within an arm's length of the controls. That's page 16 of Miss Sergeant Niles' deposition, beginning at line 18.
Yes, and I read that.
Well, then counsel for USAA is not here or participating today, but counsel for USAA, when it became her chance to ask some questions, said to Sergeant Niles, what were you referring to by him standing on the corner of the truck? This is page 23 of the deposition.
Let me find that.
And he talks about various.
That was exactly the question I had. Did somebody follow up and develop that? I didn't take the time to read all of your attachments, so thank you. You said page 22?
23, beginning at line 6.
All right, hold on. Okay, I'm with you.
Okay, the question is, what were you referring to by him standing on the corner of the truck? And he talks about various things, but the key sentence is the very last one, beginning at line 19, where Sergeant Niles clarifies. He says, I drew that conclusion based on all those facts that he's standing in close proximity of the back corner of the truck, not standing on the corner of the truck, standing in close proximity of the back corner. So I don't know if it was when he originally said, I believe he was standing on the back corner, he meant at the back corner, but that's certainly what, on further examination, he clarified that he was saying he was standing in close proximity to the back corner of the truck. And then finally,
Let me stop you for just a second. I wanted to read the context here. This officer didn't see the impact. He's evaluating the scene and offering a judgment from his perspective of examining the scene as to where everybody was when the accident happened. Is that right?
that's correct. And again, my partner, Mr. Ryan, made a good point of clarifying that at page 27, beginning at line 5, he says, so when it comes to whether or not at the time of the accident, Mr. Pratt actually had his hands on some lever or some switch or some button or whatever he needs to do to touch to initiate this, you don't know one way or the other at the time of the accident whether he was actually touching the garbage truck in any way, do you? And he said, I don't know that. No, I don't. I don't think he can be any clearer. He doesn't know if he is even in physical contact.
So let's back up then. As Mr. Millenbach was explaining, and maybe I misunderstood, I was under the impression that the other man, what was his name? Street?
Street.
He himself
Street.
was the one who was operating the controls at the time of the impact, because he was emptying the receptacle that he had from his side of the street.
Right.
That's correct.
So this officer couldn't have been more wrong about who was at the controls at the time of the impact.
Right. I think, Your Honor, it's also important to note, we emphasize this in our reply, Mr. Street, although he admits he didn't see the actual impact, the last time, moments before the impact, that he saw Mr. Pratt, he said his feet were on the ground. I mean, not on the truck, his feet were on the ground. So he wasn't standing on the truck, the last eyewitness to see him. You know, what this case brings to mind is the Michigan Supreme Court's fairly recent case, the Lowry case, where they talked about what's the burden here on a C-10 motion. And they said, look, defendants don't have to disprove an element of the plaintiff's case. A defendant is entitled to summary disposition under C-10 if the plaintiff is unable to come forward with evidence on an essential element of the case. And I think that's exactly what we have here. Yes, we can all postulate and come up with, possible scenarios as to what Mr. Pratt was doing at the moment of impact, but we have no eyewitness, certainly. We have no witness that's going to place him upon this garbage truck. The Westfield case, let's assume for sake of argument that there's some evidence here that we could draw an inference that Mr. Pratt was hands-on the garbage truck for whatever reason. That's exactly the situation we have in the Westfield case, where in Westfield, the plaintiff was claiming that he had a tow truck. He claimed that he was upon the vehicle because he had both hands on it, was leaning against it for balance and support at the time of impact. And the Court of Appeals, interpreting identical policy language as to occupying, said that's not being upon the truck. And in Rednor, if you look at Rednor, the court noted that the Court of Appeals, in what's come to be known as Roman numeral II, suggested that a person not be completely supported by an object to be quote unquote upon it. And the Supreme Court spoke critically of that and said, no, physical contact's not enough. And certainly we've cited a legion of cases that from other jurisdictions as well, that if for some reason physical impact of a collision drives you upon or into a vehicle, that's not going to qualify as being upon the vehicle at the time of the accident. That activity of being upon has to occur prior to the accident. And this is a tragic accident.
Let me ask you, what if he jumped onto the vehicle to try to avoid the impact from the pickup truck? That would place him on the vehicle, wouldn't it?
Yeah, that would place him upon or on the vehicle. But again, we don't have, not only do we not have an eyewitness to that, we don't have, for example, a biomechanical expert who's opined in this case that because of this, that, and the other thing, I believe he was, upon the vehicle at the time of the impact. Quite frankly, I've had that in other cases with this particular policy provision, but we don't have that in this case. I mean, we're left to speculate.
Is there enough accident reconstruction, not by an expert, but just by the lay people that saw the immediate aftermath, to know where exactly in the back of the garbage truck Mr. Pratt was at the time of impact?
I don't believe so. In fact, I think there was an honest effort by all counsel at the depositions of the various witnesses to see if anybody could offer that kind of an opinion. And they all said, look, I'm not an accident reconstruction expert. I can't say.
Was the driver of the pickup truck deposed?
Yes.
No, we didn't depose Mr. Eggleston. It was my understanding that he didn't see anything before he struck.
Oh, no, I'm sorry. You're right. You're right, Mr. Middleback.
How could he not? Because of the sun being in his eyes?
Yeah, and he also had a windshield. He hadn't used that truck except for periodically or occasionally to haul his camper. So he was taking it to the gas station to go before his trip to get some windshield washer solvent because his windshield was so filthy.
I've got an old beater pickup truck that I use mainly in the winter for hauling firewood. And after it's been sitting under the trees for a period of time, you can't see through the windshield. There is so much garbage on the windshield. Vision it just wouldn't be safe to drive it in that condition. That may be the condition it was in. It's hard to imagine he didn't see a garbage truck. I mean, what in the world was he doing driving down the road if he couldn't see a garbage truck?
I know.
Might I add, especially if he was up on the truck and not see him. I mean, that's even less likely.
Yeah, irrespective of whether he saw Mr. Pratt, he should have seen the garbage truck.
I know. It's reprehensible, actually, that somebody could drive in a car in that type of condition on a highway facing east into the sun, regardless of where he was going, even if he was trying to correct the problem.
And even a slightly dirty windshield with sunlight shining directly on it makes it even harder to see anything. That's how I know when my windshield needs to be clean, is if I'm driving along and all of a sudden I get a lot of sunlight directly head on, and I can see every speck that's on that windshield, and I know, oops, I didn't realize it was that dirty.
I think if you look at the investigative law enforcement statement, and Mr. Millenbeck can certainly correct me, I think these people were on their way to vacation. You know, it was early in the morning. So who knows? I mean, he might have been distracted, but.
Yeah, I think that just in response to Mr. Schutz's arguments about, you know, it's pure speculation. It's not speculation at all. There aren't any direct eyewitnesses to it, but certainly circumstantially, there was a witness who said that he could have been standing on the gate or the step, Mr. Street, before the accident, which would indicate that he would have jumped up on it. And circumstantially, when he was found at the scene, he was found up on top, laying on the hood of the pickup truck with his feet well off the ground, which would reflect that when he was struck, he was higher up than standing on the ground.
Well,
circumstantially can be determined by the jury. And I'm not saying it's not an uphill battle, but I don't think that's the standard here. And certainly there's a question of fact of whether or not he was standing on the ground or standing on the back of the truck or standing on that little step or gate at the moment before impact. And certainly clear that he could have jumped up onto that truck when he saw the pickup truck coming.
For a jury to conclude that the reason he was located where he was after the collision was because he was upon this garbage truck, that's speculation. I'm sorry.
How else did he end up on the hood of the pickup truck?
I don't think plaintiff knows.
Well, I think you add all of these, you stack all those things together and add them all up. He was probably standing on the back of the truck, and that's something for the jury to decide. And if they don't buy it, if they don't, I don't say buy it's the wrong word, but if they don't feel the same way, then so be it. But ultimately, they should be the one to decide that.
Again, there's a big missing element here, and that's fatal, I believe, in this case.
What's that?
I'm sorry.
What's the fatal missing evidence? I want to make sure what you're saying.
Evidence that the decedent was upon this garbage truck at the moment of impact. You know, there is one case that one of the parties cited, and I think it's an example of what the Supreme Court has previously ruled, or it is an example what upon means, and that was the Royal Globe versus Farm Bureau case. It's a 1984 Michigan Supreme Court case where they found that a person who was riding on the hood of a car that was involved in an accident was someone deemed to be upon the insured vehicle at the time of an accident, and therefore entitled to lay claim to benefits. We have nothing in this case. We have no evidence that he was on the truck, that he had reason to be on it. He wasn't riding along. He was, as the courts noted, this wasn't a situation where they're riding down the road and it's, you know, there's likelihood that one of the workers is going to be standing on the back of the truck. No, there'd be no reason for him to be standing on the truck before the impact, and there's no evidence that he was. And again, the only person that can comment on the position of Mr. Pratt moments before the accident is his coworker, Mr. Street. He tells my partner, Mr. Ryan, I saw both his feet on the ground.
Also said he could have jumped up on the gate on the back of the truck.
Okay.
He was standing right there.
Could that have happened?
In the world, there's every reason in the world for him to be on the back of the garbage truck. If he sees a car coming, he feels there's nowhere else to go. I probably would have jumped in the hamper too. The hopper.
Okay, thank you, gentlemen. I mean, the evidence is scant, but I really have trouble understanding any mechanism by which he would have ended up on the hood of the pickup truck if he were standing flat on the ground at the time that this impact happened. I can imagine how he would have ended up on the truck of the hood of that pickup truck if he was in fact standing on the vehicle or was in the process of trying to get up on the vehicle, partially on, so that he's up off the ground some measure. Otherwise, knowing a standard pickup height and the height, there's no way in the world he would have been up on that. That pickup would have struck him mid-torso. There's no mechanism in the world that I can fathom that would explain how he would have ended up on top of that pickup truck if indeed he was standing flat-footed on the ground at the time of the impact. So I think there is a genuine issue of fact for that reason, and I'm going to deny the motion. Mr. Millenbach, you would please prepare an order reflecting denial of the motion for the reasons stated on the record.
I will, Your Honor.
Thank you, Your
very
Honor.
much.
Thank you, gentlemen. Have a good day.
You too, Your Honor.